One of the first legal business decisions you must make is whether to operate through a limited liability company, commonly called an LLC, or a corporation. The right choice can affect liability protection, taxes, management, ownership, record-keeping, financing, and the long-term growth of your business. Before filing formation documents, it is important to understand the practical differences between an Oklahoma LLC and an Oklahoma corporation. What is an LLC? An LLC is a flexible business entity under state law. Many small business owners choose LLCs because they combine liability protection with simpler management and fewer formalities than a traditional corporation. Oklahoma requires most new business entities, including LLCs, to file formation documents with the Oklahoma Secretary of State before they can legally operate as registered businesses. The Oklahoma Business Portal also notes that new businesses may need to register with the Oklahoma Tax Commission or other state, city, or county agencies depending on the nature of the business. An LLC is owned by members. The members may manage the company themselves or appoint managers to operate the business. For many small businesses, this flexibility makes an LLC attractive because the owners can structure control, voting rights, profit sharing, and management duties in an operating agreement. What is a corporation? A corporation is also a separate legal entity under state law. Corporations are owned by shareholders, managed by directors, and operated by officers. Corporations usually involve more formal structure than LLCs, including bylaws, shareholder meetings, director meetings, minutes, resolutions, and stock records. A corporation may be a good option when the business expects to raise capital from investors, issue stock, create different ownership interests, or eventually sell ownership shares. The corporate structure is more rigid, but that structure can be useful when there are multiple investors, shareholders, or growth plans. Liability protection. Both LLCs and corporations can provide liability protection when properly formed and maintained. This means the business entity, rather than the individual owner, is generally responsible for business debts and liabilities. However, liability protection is not automatic for every situation. Owners may still be personally liable if they personally guarantee debts, commit wrongful acts, mix personal and business funds, fail to maintain the entity properly, or use the business as an alter ego. For many Wagoner County business owners, liability protection is one of the main reasons to form an LLC or corporation. Whether the business involves construction, rental property, trucking, retail sales, professional services, restaurants, farming-related operations, or local contracting, separating personal assets from business risk can be extremely important. Management and flexibility in LLC is usually more flexible than a corporation. The operating agreement can be drafted to fit the owner's goals. Members may divide profits in ways that do not exactly match ownership percentages, create different voting rights, restrict transfers, and define how major decisions must be made. Corporations are usually more formal. Shareholders elect directors, directors make major policy decisions, and officers handle daily operations. This structure may feel unnecessary for a small owner-operated business, but it can be useful when the business has several investors or plans to grow beyond a closely held company. Tax considerations. Taxes often play a major role in choosing between an LLC and a corporation. The IRS explains that the business structure determines which income tax return a business must file, and legal and tax considerations are both important when selecting the entity type. By default, a single-member LLC is commonly treated as a disregarded entity for federal income tax purposes, while a multi-member LLC is commonly treated as a partnership. However, an LLC may be able to elect to be taxed as a corporation or, if it qualifies, as an S corporation. This means an LLC can provide legal flexibility while still allowing certain tax elections. A traditional C corporation generally pays tax at the corporate level, and shareholders may also pay tax on dividends. An S corporation can provide pass-through tax treatment, but it must meet specific IRS requirements. The Small Business Administration explains that an S corporation is useful to avoid the double taxation drawback of regular corporations. Because tax treatment depends on income, payroll, ownership, deductions, distributions, and future plans, business owners should consult a CPA or tax professional before deciding which structure is best. Record-keeping and formalities. LLCs are usually easier to maintain than corporations. Although LLC owners should still keep accurate records, maintain a separate bank account, document major decisions, and follow the operating agreement, LLCs generally require fewer formal corporate procedures. Corporations require more formal governance. Shareholders, directors, officers, bylaws, stock records, meeting minutes, and written resolutions may all become important. These formalities can protect the integrity of the corporate entity, but they also create more administrative responsibility. Raising money and adding owners. If the business plans to raise money from outside investors, a corporation may be the better choice. Investors often prefer corporations because stock ownership is familiar, easier to transfer, and easier to structure for investment purposes. Corporations are also more common for businesses that expect rapid growth, venture capital, or eventual sale. An LLC can also admit new owners, but ownership is usually through membership interests rather than stock. LLC ownership transfers may be restricted by the operating agreement and may require approval from the existing members. For closely held businesses, that may be a benefit. For investor-focused businesses, it may be a limitation. Local business considerations. In Wagoner County, a Wagoner County business may also need to consider local licensing, zoning, sales tax obligations, employment tax obligations, contracts, insurance, and industry-specific regulations. Oklahoma's New Business Center notes that starting a new business may require registration with the Oklahoma Tax Commission or a different state, city, or county agency. Forming an LLC or corporation is only one part of starting the business. Owners should also consider written contracts, leases, employment policies, customer agreements, liability insurance, bookkeeping procedures, and a clear separation between personal and business finances. When a corporation may be the better choice. A corporation may be the better option when the business plans to seek outside investors, issue stock, create a formal board structure, reinvest profits, provide certain employee benefits, or eventually sell shares. Corporations may also be better when the owners want a more traditional structure with shareholders, directors, and officers. The corporate structure can be more burdensome, but that additional structure may help businesses that expect significant growth or complex ownership arrangements. The importance of an operating agreement or bylaws forming the entity is not enough. An LLC should have a written operating agreement that explains ownership, management authority, voting rights, profit distributions, buyouts, transfers, death or disability of a member, and dispute resolution. A corporation should have bylaws, stock records, minutes, and resolutions documenting important decisions. Many business disputes arise because the owners never clearly agreed on what would happen if someone wants out, stops working, dies, divorces, contributes less money, or disagrees about the future of the company. Good formation documents can prevent expensive litigation later. For many small Wagoner County businesses, an LLC is often the most practical choice because it provides flexibility, liability protection, and simpler administration. However, a corporation may be the better choice for businesses with investors, stock plans, more formal governance needs, or specific tax strategies.